This is going back a little ways. This goes back to February 23rd in Georgia. We're talking specifically about Ahmaud Arbery. Remember Ahmaud Arbery? We've got Gregory McMichael there on the left. We've got Travis McMichael on the right. This was a pretty big, pretty controversial case that took place out of Georgia. And as a quick recap, let's remember what happened. The original claim was that Ahmaud Arbery was running down the street and he was just going for an afternoon jog. Travis McMichael, Gregory McMichael were both there in the neighborhood. Gregory McMichael was a former police officer or investigator or had some involvement with the prosecutor's office in his locality. And they decided to take things into their own hands. They thought that there was a series of break-ins going on, and because they saw a black man running down the street, they thought that was the person who was responsible for it. They get into their car, they chase him down, and when he sort of continues to flee from them, they circle around, block him off, they kind of barricade him in, and then we saw that video that was very short, very shaky, very grainy, but Travis McMichael, the son, actually pulls a shotgun on him and shoots him, ends up shooting him 3 times. Ahmaud Arbery, of course, dies. And this was a case that sat around for a long time, about 60 to 90 days. It sat in the prosecutor's office. It got kicked around by multiple different prosecutors. Nobody wanted to bring any criminal charges against the McMichaels for false imprisonment or for murder or for getting involved in something that they shouldn't have been getting involved in, for not calling the police and letting them deal with it. All sorts of complaints about this. Then somebody leaked a video. I believe it was the defense attorney leaked the video to the public, and we all saw what happened here. And then we got to sort of put things back together and say, why did it take so long for anybody to look into this? And it turns into this situation where the public starts clamoring. They get sick and tired of this whitewashing, of this trying to sweep everything under the rug, and they demanded that charges be filed. And they were. And so Travis and Gregory McMichael and their friend, a neighbor, Roddy, were all charged with various different crimes. And, a lot of the time, my perspective on these things is I get concerned that once the initial outrage, once the initial furor sort of dies down, I'm wondering if these cases are just going to fall by the wayside. Everybody's going to forget about them, except this channel, of course, which is why you're here. But what we want to do is we want to just continue to follow them along. And actually, there's some pretty interesting things going on here. It looks like that the prosecutor's offices are actually not letting this one up as lightly as I would have otherwise thought. And so today what we saw, there were new filings literally that happened today right before the show started. We have out of the state of Georgia, out of Glynn County, we have notice. The government is filing an intention. They're letting the court know that they intend to introduce evidence in aggravation of the punishment. So notice of the state's intention to introduce evidence in aggravation of the punishment. So let me explain what this means or what this type of motion is. So let's say you probably have heard of mandatory sentencing. You've probably heard that, if you go to trial and you lose, if you're convicted of a crime, the judge can only sentence you to a certain range. So they can say, well, you're going to get 5 to 10. You probably heard that, right? That means that the judge can't give you less than 5 years, but can't give you more than 10. Has to sentence you within that range. And so when you're looking at that sentencing box, and in Arizona we use charts, we have these spreadsheets and charts and these little formulas, and we can flip through them and all that stuff. What we're talking about is when you say, okay, in that 5 to 10, we say that most cases will start at what's called the presumptive. So we'll start at, let's say, 7. So if you got charged with that crime and convicted, and I did too, and my friend did too, we're all going to start at 7 years. And what the defense's job is to try to do, it's to work the case down. We want to work it as close as we can possibly get to the 5 years. Let's work from 7 down to 5. The government's job, or what my perspective on their job is, they may disagree with this, is they're trying to push it the other way. They're trying to maximize it. They're trying to aggravate it. So how do they get from 7 to the 10? They introduce aggravating factors. And what they have to do in order to have the judge know about that and to actually sentence this person is they got to tell the court. And so that's exactly what they're doing here. They're filing a notice of the state's intention to introduce evidence in aggravation of the punishment. And we can see here, they're just saying that in the event of a conviction, the state will take the following action at the sentencing phase of the said trial. So this is not going to introduce anything into the underlying trial itself, but the state intends to introduce evidence that that there are other, any other convictions, any other juvenile adjudications, any other crimes of the defendant that they learn about when the government gets discovery back. Remember, we talked about the government has to disclose evidence to the defense. The defense has to disclose the evidence that they want to bring at trial back to the government. And so this portion of this is saying that if they learn that there are other convictions, they're going to use that to aggravate the sentence. They're also going to be saying that they intend to seek punishment of the defendant, which would authorize this court to impose a sentence of life without the possibility of parole for a conviction of the offense of murder. So they are saying that they are going to be asking for the maximum. And they have to put, a lot of the time when you have these state statutes that you're going to be asking for life in prison or the death penalty, you got to notify the court. And so that's what they're doing here. I was sort of the mindset, and this could certainly change. This could be just formulaic, and they're just filing this as a matter of due course, and then they're going to offer them a sweetheart plea deal later down the road. That could be the situation, or it just could be the situation that they don't intend to offer a plea deal at all. Maybe they have more evidence. Maybe they have evidence that we have not seen yet. Maybe they've got text messages or emails or phone calls or other witness statements that indicate that the McMichael's are even more culpable. The sort of the situation was even more egregious than we as the public knew. And remember, most of this stuff came out through leaks. This was pre George Floyd. And so a lot of the immediate transparency that the public now expects and that the police departments are actually sort of evolving into, a lot of in Phoenix, they have really rapid response now. They're getting these body cam videos out to us quickly, which is great. I think that's good. We want more of that. We want more transparency. But my point is, there may be more stuff that the government has in their Travis McMichael file that we don't quite know about yet. So that was interesting. They are going to be at least notifying the court. They're going to be aggravating the sentence for both the McMichael's, and we'll see where that goes.